There can be no meaningful people-centered approach to justice if justice seekers don't believe that courts can adjudicate cases impartially and without external pressure.
The issue at hand started from a ruling by the Deputy Registrar of Mbarara High Court, Nanteza Zaliika, when she declined to grant an interim injunction application filed by one Francis Ishanga in a land dispute against Kellen Karemera and others. In this case, Francis Ishanga wanted court to issue an injunction halting Bank of Baroda together with Karen Karemera of his commercial property in FRV 1700 to Foil, plot number 1 in Ichitunzu Road, Kamikaze in Mbarara City. Robert Mwesigwa, Member of Parliament for Mbarara City North, wrote to the Minister of Justice and Constitutional Affairs, Nobati Mau, asking him to intervene in the case. In Minister Mau's letter dated 19th March 2024 to the Principal Judge Dr. Flavian Zaija, he asked for his intervention to call and examine the ruling. On top of this, Minister Nobati Mau also ordered the Acting Inspector General of Police to restore the status quo at the dispute land until the conclusion of the judicial process. It's against this backdrop that Uganda Law Society has expressed concern to the Minister's Act, alleging interference with the judiciary's independence.
In our view, the Honourable Minister overstepped his powers by asking the court to reinstate the status quo. Now, Article 128(1) of the Constitution says no one should, first, the courts are independent. Two, no one should interfere with the courts when they make their decisions. Now, in this particular respect, there was a court order, and the Honourable Minister is calling upon the Assistant Inspector General of Police to reinstate what we call the status quo, or what you would actually call the way things were before the court order was made. That in itself is wrong. First of all, court orders must be respected. Whether you agree with them or not, court orders must be respected. That's the fundamental purpose of what we call rule of law. Because if we don't respect rule of law, then we'll go into a system of anarchy. So it is important, number one, that court orders must be respected. The minister does not have powers, however justified he may have been, or however well-intentioned he may have been, to reinstate the status quo without a court order having been varied or appealed against. So in our view as Uganda Law Society, it is important that court orders are respected. That's a fundamental principle of justice.
Oundo says with such acts, this erode public confidence in the judiciary to the extent of not respecting court orders and rulings.
I've heard people talk about judicial accountability. I've heard people talk about judicial independence. Let me just clarify these two issues so that we are all on the same page. Judges make decisions, and of course in making decisions there can be places where they will reach unjust conclusions. For instance, they misapply the law or they misapply the facts and therefore reach a wrong conclusion. That is solved through the appeal process. So if you're dissatisfied with the decision, what you do is you appeal to the next level. So in Uganda, we have chief magistrates courts, we have the High Court, we have the Court of Appeal, we have the Supreme Court. If you feel that the decision is unfair, and perhaps you are the Chief Magistrates Court, you can appeal to the High Court. If you feel a decision is unfair and you are the High Court, you can appeal to the Court of Appeal. And if you feel the Court of Appeal is unfair, you can also appeal to the Supreme Court. So there is a self-correction mechanism under our law that allows that allows the legal process to continue if you feel that the process, the decision that has been reached is unjust. The other situation is what we call judicial accountability. Judicial independence does not mean that judges are not accountable. There are instances, for example, where they can misuse their judicial power, and it is called abuse of judicial power. They can abuse their judicial power, where they act manifestly in ways which abuse their judicial power. They have judicial power of discretion, and those situations happen. The Constitution has gone ahead to provide that if you have any complaint against a judge and you feel that they have intentionally, in bad faith, acted wrongly, then your self-correction mechanism is with the Judicial Service Commission. So the Judicial Service Commission has power to receive complaints from any person against a judge who has misused his judicial power. So there's a difference. So we are not saying that judges are not accountable. Judges are accountable to the people of Uganda. Judges are accountable through Article 2 of the Constitution of Uganda. The people of Uganda are supreme. Okay? Judges are accountable. This same constitution has provided for what we call the Judicial Service Commission.
This is not the first time Uganda Law Society has raised concern over the tamperance of judiciary's independence. Of recent, the Society expressed concern over the President's letter to the Chief Justice in Justice Kyabaho and Uganda Muslim Supreme Council case. It
is a dangerous precedent, and it's important that we don't create that precedent where you have ministers writing to the courts. It's a very dangerous precedent for the rule of law and for the independence of the judiciary. And our role as Uganda Law Society is to continue to point out when these issues happen, to continue to point out and say this is what is supposed to be done, as opposed to have ministers writing to courts. It's a dangerous precedent, and we all must be conscious about it, majorly for rule of law and for a democratic culture. Because at the end of the day, it shields all of us, it protects all of us. Independence of the judiciary is our protection, all of us. Because today, if I am not the president and something like that happened, however justified it was, and I don't have access to the Minister of Justice, where should I go? What about the so many people who don't even know who the Minister of Justice is? So these are the issues we are bringing out. Our Constitution recognizes these challenges and says, if you have any complaint, please go to the Judicial Service Commission. It doesn't mean that when we argue for judicial independence, we are saying that judges are not accountable. Judges are accountable to the people. Judges are accountable to the taxpayers because they are serving us as Ugandans. And therefore, if they abuse their judicial power, there is a system through which they can be disciplined. And that disciplinary mechanism is through the Judicial Service Commission. So the Honorable Minister would have referred the matter to the Judicial Service Commission and asked the lawyers to appeal the decision or order they thought was unfair. It is only through that process that we ensure that we have a legal process that is continuing and that is accessible to everyone.
President Uganda Law Society Bernard Owundo, however, dismissed allegations of having a conflict of interest in such cases, where the society has always raised concern.
We are going to say that today we have an independent judiciary, but every single day we must continue to fight for the independence of the judiciary because it's important. The judiciary is the only arm of government where we, all of us, if we have any dispute, we have submitted our power to the authority in the court, and we are saying that when the court makes a decision, we shall abide by it. Okay. So in terms of the principle of separation of powers, and it's not really an absolute principle of separation of powers, it's what we call checks and balances. Mm-hmm. So you have the judiciary, you have the legislature, and you have the executive. So independence of the judiciary is something that we have to keep advocating for. And as you can see, as the Uganda Law Society, we keep pointing out the issues that affect the independence of the judiciary. Our hope is that as we continue to point out these weaknesses, these issues that affect the independence of the judiciary, we will continue to reach that destination where we can say we fairly have an independent judiciary in this country. So as Uganda Law Society, we continue to advocate within our mandate of the Uganda Law Society Act for an independence of the judiciary. Because independence of the judiciary is one of the hallmarks of a democratic country. It's one of the hallmarks of rule of law. Imagine, for example, in this instance that we are talking about, what about those people who don't have access to the minister? Where do they go? This is why we find this a problem. The fact that if I cannot have access to the minister, then I don't have a remedy. That is not how a democracy should work. A democracy works because you say you have created a Judicial Service Commission. You have created a Judicial Service Commission that has power under the law to handle any complaints that come. So all of us people, all of us, if you have a challenge with a judge who is abusing his judicial power, you can go to the Judicial Service Commission. So when you have a minister engaging and trying to give instructions to an inspector of police to reinstate this without a court order, that is a dangerous precedent. Because tomorrow you're going to have every minister trying to be able to use his power. So when will this end? And I think it's important to distinguish. One, judges must apply the law to the facts and the evidence before them. And in doing that, they can reach a wrong conclusion. And as lawyers, we are taught that if a judge reaches a wrong conclusion, what you do is appeal. You go through the appeal process and say, I was before this judge, but I did not like the decision that he gave me, so I'm going to the next court. But again, a judge can abuse their power, and that is true. Judges can abuse their power. Now, if a judge abuses their power, we also still have a mechanism through which we can deal with it, and that is the Judicial Service Commission. Our constitution, the same constitution that talks about judicial independence in Article 127, 1, 2, and 3, also talks about the Judicial Service Commission in Article 147. It therefore recognizes that yes, we have judicial independence and we encourage judicial independence, but we also understand that judges must be held accountable. And how are they held accountable? Hold them accountable through the Judicial Service Commission. You can actually discipline them through the Judicial Service Commission.
UBC TV tried to reach the judiciary spokesperson James Eremi Mawanda over the issue at hand, and he had this to say.
The ULS letter is their opinion. It is their opinion, and we have no control over their opinion.
While at the 25th Judges Conference, the Minister for Justice and Constitutional Affairs, Nobati Mau, pledged to deal with whoever tampers with the judiciary's independence.
That speaking for myself, and I believe the executive, it would be wrong to seek to remove a judge from office for the sole purpose of achieving a political end. It is wrong for public officials to attack an individual judge. My duty is only to balance judicial independence against judicial accountability.